All right. Again, thanks to everybody for attending. This is Region 10 RTOC's first webinar, hopefully of many, where we intend to cover timely topics that may be impacting environmental issues in Region 10 or related to environmental issues facing tribes in Region 10. I'm Rick Eichstead. I'm the Region 10 RTOC's policy advisor. I'm based in Spokane, Washington. For those of you who don't know, the Region 10 RTOC is an advisory body that is made up of tribes from Alaska, Washington, Idaho, and Oregon. We meet regularly with EPA Region 10 leadership. We do not serve as a replacement for consultation, but as an advisory body for EPA. You may have attended one of our conferences, the Tribal Environmental Leaders Summit, which we generally put on annually. Stay tuned. That's planning for the next one is in the works. As well as we often participate in regional conferences and make ourselves available for assistance for tribes. For example, we regularly put together comments on EPA proposals. Grant, who you'll be hearing from shortly, and I were just discussing the Waters of the U.S. rule changes that are proposed, and comments being put together by the RTOC on that. So with that, I want to turn it over to Oksenia, who we're very excited recently joined our team as our new RTOC executive director.
Thanks, Rick.
Yeah, of course.
I don't know if my camera is on. Okay, thank you. So welcome everybody. I'm super excited for the webinar today. Like Rick was saying, my name is Oksenia. I am the new executive director here at RTOC Consortium. I am originally from Chignik Lake on the Alaska Peninsula. I am Sukyakin and a member of the Unga tribe. I just wanted to say a quick hello and get everybody used to my face. I'm super excited to join the RTOC team and being able to elevate tribal voices as we move forward. And I think I will hand it back off from there. I just wanted to say a quick hello.
Thanks, Oksenia. Now you'll be hearing from our speaker, Grant Thompson, who is our legal research intern. Grant just graduated from Gonzaga University School of Law. So he is a brand new lawyer and will be taking the bar this summer, right, Grant?
Yep.
So,
July.
Yeah, I will turn it over to Grant, and feel free, Grant, if you want to share anything else about yourself before you get started.
Well, I don't know if I honestly have enough time to share anything about myself.
All right, you can just get going then.
Yeah, I did teach university for a few years, and so I know I can talk a lot. And so bear with me if this runs a little long. We're going to try to stay on point. But today, I just sort of want to go through what executive orders are, how they work sort of in an ideal world, what's going on right now with these executive orders, and what can be done about that, both for the orders that are on their face valid and the ones that on their face are not valid. And a lot of it is going to sort of circle around this picture here, which is President Donald Trump trying to be Andrew Jackson. So I'll go back to that one or two times a little bit later in the presentation. But our general layout is going to be 3 main points. First off, in order to understand what an executive order is, we have to know what the executive does. And so there are really 2 relations going on. How does the executive relate to the legislative branch? And then when that relationship sort of breaks down, when the executive is doing too much, how is that checked? How does the judicial branch get involved? And then within all of that, we look at what executive orders are doing. The real quick takeaway, executive orders are telling the administration, all that the executive does, how to do its job. They can't change that job because Congress says what that job is, but they can change a lot about how that agency does that job. Then we'll briefly talk about if the executive is saying, let's do way more than we're allowed to, what do courts have the power to do to restrain them? And then we'll end by diving into about 5 current executive orders, which really run the gamut of things that are decently normal to things that will have pretty significant ripple effects, pretty significant consequences. And then end on hopefully a somewhat uplifting note of what can be done. So first, this is going back to sort of Schoolhouse Rock, basic civics. 3 branches of the government. The legislative branch, think of Congress. They're the ones making laws, and laws are really broad, just sort of broad brush strokes. Let's say we should build a house. Congress is the one putting up walls. They're framing the house. And so they are the only ones that can actually put up walls to set regulations. The thing is, those are often really vague. So it might say something to the effect of, we shouldn't have undue drilling restrictions. But then that goes to the executive that has to take those really broad laws and apply them to everyday life. Well, what does undue mean? If Congress says you can't set prices too high, the executive is the one that says, well, $12 is too high, $11 is not high enough. And so they're the ones who show up, they see the wall is built, and they kind of get to choose what drywall, what paint color, how many pictures to frame on that wall. In other words, they are filling out all of these details and making it so that we have a law that we see, that we understand. And so they're, in a lot of ways, translating and applying the law. And then the judicial branch is sort of separate from the others, and it's mainly there to say when someone went wrong. They look at the legislative and say, you can't do that. They look at the executive and say, you can't do that. Maybe because the executive is coloring outside of the lines, or any other of a whole litany of reasons. The main thing, though, is that the judicial branch is responsive. Whereas Congress can make a law any day of the week, and the executive is constantly applying those laws, the judicial branch only comes in when there's a case before it. When enough people get up and say, we are suing this agency, we think this is wrong. So keep in mind, the judicial branch is only involved when they're asked to be involved. So, going back to what an executive order is, we have to work out what an agency is. Because at its core, an executive order is merely the president telling agencies how to do their job. The thing is, there are dozens of agencies. Over here, we have the official organization chart for the United States government. And so legislative branch, very tiny little square, judicial branch, very tiny little square. The executive just spreads and spreads and spreads. And all of those agencies are different parts of the president's power. The president's power to take those laws and apply them to everyday situations. So agencies, just think of them as arms of the White House. They enforce the laws created by Congress, and they promulgate rules. And I'm sorry, promulgate just means create or pass. Every once in a while, I realize law school broke me, and I don't speak like a regular person anymore, but I'm working on it. The point is, agencies are there to fill in those details, to choose the paint colors that are already going to go on the walls Congress built. The thing is, they cannot exceed the authority given by Congress. So when Congress creates a rule or creates a law, and they delegate some authority to the executive branch, to an agency to fill in those details, the agency can't show up and say, oh, by the way, we're going past that. We're building on this whole annex to the House. That is going to be unconstitutional. That would be something the courts get involved in. The other important thing is that when these agencies create these sort of details, those details have the force of law, but only when they go through the right procedures. These procedures are governed by the Administrative Procedures Act, which is about 3 pages long. And it just says, whenever you're making a regulation, you have to follow a certain set of rules. In most cases, you have to publish a notice saying, this is the rule we hope to pass, and wait for public comment. Once you get those public comments, you have to meaningfully respond to every substantive comment. Without that, you are not meeting the requirements of the APA. And without that, you are now doing an unconstitutional act. The other important thing is that these regulations cannot be arbitrary or capricious. In other words, the agency has to have some justification for what it did, why it picked that regulation versus another one. Unfortunately, this is a remarkably low bar. It doesn't have to be the best answer. And this is something that we'll see the current administration is using and using and using and relying on, because they often don't have the best answer. But if they are able to explain a justification for it, that's enough. The main thing about this is, in order to do those things, they have to jump through these hoops. In order to actually change the regulations that are applying these laws to everyone, they have to go through notice and comment. And they have to present some case in writing on why that is the best plan of action. So, with that in mind, what's an executive order? Really, an executive order is just telling all of these agencies what they should do. It's saying, we just bought this house. We have these walls. Congress put them up. The last administration painted them. As president, I want all of the agencies to start using more pastel colors, as an example. It is telling all of the agencies by themselves what they should be doing. And so most of these executive orders have the phrase, each agency shall. The other significant thing is they tend to say, as consistent with appropriate law. That means there's a recognition that they are bound within the framework set up by Congress. They can't go too far afield. However, within that pen, the executive, the president, wants agencies to act a certain way. Because these are merely asking other agencies to change regulations, they aren't laws in themselves. The executive order tends to have no force by itself. It has force because it's telling the agencies to do something through the proper channels, and they have the force to then apply laws to people. So that is sort of one of the foundational things to understand about most of these executive orders. Naturally, there are a few oddballs. We'll get into those. So within that context of here's an executive order, here's how it works, here is sort of the enclosure within which the executive has to act, what happens when the executive doesn't act that way? In theory, that's when the courts come in. The courts wait for a lawsuit or a criminal trial, and then once the question's before them, they say yay or nay. They say whether the agency has gone through all of the hoops, all of the hurdles of the Administrative Procedure Act. And if they didn't, then the court holds that branch and says, you can't do that. The court essentially says, this is unconstitutional. The executive has to fix it. Reel that back in, and that usually winds up with the regulation going back to its previous state. Now, one of the very valid questions is, what happens when the president says no? And in practice, the court does have a few different ways to enforce their decisions. The court has the power to issue contempt orders, essentially saying because the court said it, the court has the ability to enforce it. I mentioned writ of mandamus just because it sounds very Latin, but this one is actually very rare, and it's only in the small set of circumstances where an agency has to do something. Usually there's enough leeway, enough obscurity with Congress's laws. That one's probably not going to get involved. So we're mainly talking about orders of contempt. And then those orders are enforced by the federal marshals. The federal marshals are supposed to listen to the courts. The crux is they are under the Department of Justice. So when everything is working really smoothly, that's not an issue. I have hopes that's not going to be an issue. However, we have a couple of different historical examples of ways that presidents have addressed the court telling them what to do. One of the shining examples is Brown versus Board of Education. In that case, the Supreme Court says segregation is bad and forces all of the schools to integrate. The thing is, the southern states do not like that. And so the governors of the many southern states refuse the court order, and then Eisenhower says, the court has spoken, I'm sworn to uphold the Constitution, and he obeys. And so he sends in the 101st Airborne, and they, as federal troops, enforce the court's opinion. In contrast, we have Andrew Jackson. So back in the 1830s, there was one of the watershed cases in federal Indian law, Worcester versus Georgia, which I guarantee I'm pronouncing wrong. In this case, there was a missionary that went into Cherokee lands and then was arrested by Georgia for doing so. Through this case, we have a lot of really good precedent that essentially says tribes are sovereigns. Tribes have their own rights, and states cannot intrude upon those rights. That meant that the state of Georgia had to release Worcester, the missionary, because it was not their jurisdiction involved. The thing is, Andrew Jackson was no friend of tribes or a lot of people. And so Jackson says this famous quote, which he probably did not actually say, "Marshall has made his decision, now let him enforce it." And as a result, Worcester sits in Georgia prison for another 9 months before, changing political circumstances, the state decides to repeal this law and let the man free. The thing is, in choosing between Eisenhower and Andrew Jackson, it is very clear that Trump looks up to Andrew Jackson. And so if we're looking at which one he views himself as, we're going to be closer to the constitutional crisis of Andrew Jackson and Worcester versus Georgia. So with that backdrop, and I realize that that's a bit unsettling, but with that backdrop, let's look at current executive orders. So first, I want to start with orders that are still in place, because these so far are very good things and have not been revoked by the last 150 executive orders that have come out so far. That's an estimate, don't quote me on that. The first one is the executive order on consultation and coordination. Like most others, it starts with each agency shall. In other words, it's telling all of the agencies how they should act when they are dealing with matters that could affect tribes. And it's through this executive order that we have our reliance on meaningful consultation before action has actually been decided on, and this effort towards coordination. Has it been perfect? No. Also, because it's merely an executive order, we want agencies to work this way. It doesn't necessarily have a whole lot of teeth. It would be very difficult to use this consultation promise as an argument in court. However, it is a valuable thing. And so it's worth noting this is based on an executive order and not the sturdier congressional law. The other thing is the executive order on the preservation of sacred sites. Essentially, this one says that each agency shall administer federal land such that they prevent damaging or otherwise affecting sacred sites and accommodating access to them. The saving grace of this is that it more or less reinforces existing congressional statutes. Under the Antiquities Act and under the National Historic Preservation Act, there are some channels to get to these end results. They are more burdensome, and they are somewhat different in where the burden starts. So with the executive order, it kind of puts it on the agencies to check, to make sure, to think about their actions, whereas the Antiquities Act and the National Historic Preservation Act put the burden on everyone else to stop the agency, to designate sacred sites, which will have its own issues. But keep an eye out on this, because if it is important, which it is, then it's worth advocating for and making sure that's not among the executive orders repealed. Another significant one is unleashing Alaska's extraordinary resource potential. In doing all of the research for this webinar, I have read far too many of these titles, and as fun as they are, they get just very absurd. Anyway, like all others, it starts with saying heads of all executive departments, all agencies, under all lawful authority. So they're acknowledging this is a guideline for agencies and that these agencies are bound by the laws that created them, the laws that already restrain their actions. But within that discretion, they're supposed to permit all necessary pipelines, restart leases on the Arctic Wildlife Refuge, rescind all environmental impact statements with the idea to rewrite them and find something new, rescind all guidance for BLM or issued by the BLM. And this is particularly with a focus on subsistence resource values. We'll touch on that in 2 bullet points. Review all guidance regarding the taking of Alaska Native lands into trust, and then direct all bureaus to consider the Alaskan cultural significance of hunting and fishing and the statutory priority of subsistence management required by ANILCA. And that's one of the significant things about that bullet point is within ANILCA, Congress requires that whenever there has to be a restriction on the taking of fish and wildlife, priority, the primary priority is given to subsistence values. That one, regardless of executive order, is going to stand because Congress clearly spoke. And so the only conclusion of considering that is sort of to go back to Congress's statement, these values are given priority. So a little bit of good with the bad. However, across the board, the move is whenever a new decision is in front of an agency, that agency should try to permit pipelines, open leases, change environmental impact statements. In other words, all of these talk about later agency actions that go through notice and comment that have to follow the Administrative Procedures Act. The other big ones are dealing with funding. Essentially, the whole Doge complex of creating the organization, cutting all of the workforce, eliminating regulations, and trying to cancel as many contracts as possible. And once again, we are tasking agencies to go about this. They are all to identify regulations and rescind and modify. In order to do that, notice and comment, follow the APA. And they acknowledge that, subject to their paramount obligation to discharge their legal obligations. In other words, subject to the things that Congress said they had to do, and subject to the things that Congress said they cannot do. then they have to deprioritize regulations in a way that Elon Musk likes, that Donald Trump likes. Sorry, one second. So we're still within these checks and balances. The thing is, there is a heavy thumb on the scale because deprioritizing regulations implies not enforcing them, but Congress already told them enforce the law. And then, where consistent with applicable law, terminate contracts. Once again, this is saying within what we already have. The slight difference is that for some of these, more so than the Alaska resources one, these actions have sort of been trusted to the executive by Congress. Congress has said, well, you get to choose how to spend this money. You have to spend the money, but Congress isn't going to go through and draft up all of these contracts. That's the agencies, that's the executive. And so for some of them, particularly the contracts, there is more of a space to change tack. So, for example, under the Inflation Reduction Act, there was money allocated to achieve all of these different things. Let's start with solar. There was money allocated towards let's build out solar. The agencies then had to spend that money towards the end of building out solar. How they do that was left to the agency. And so when administrations change, and then DOGE comes in, they're able to say, we're still abiding by Congress. We are still going to spend this money towards achieving solar, but perhaps in an incredibly inefficient way, or in a way that does not value the same things that the last administration valued. But one way or another, consistent with applicable law, the money has to go where Congress wanted it to broadly. For all of those, the one very odd executive order is on unleashing American energy. And this one honestly has the biggest immediate impact next to all of the contract cancellations. So from a legal standpoint, there's a bit of oddity in the backstory. Suffice it to say that the order revokes a lot of the framework of the National Environmental Policy Act, which we think of mostly for requiring environmental impact statements and adding a few more hoops to development. Largely, that's because under the Carter administration, there was an executive order saying that a certain council, the Council on Environmental Quality, could create its own regulations. In a way that was a bit fuzzy, they essentially said, whatever the Council on Environmental Quality says, other agencies should listen to them, which is slightly different than when Congress says we have passed NEPA and this agency will promulgate all of the details. Because of that fuzziness, this administration was able to come in and say, all of those regulations are null and void. In other words, there is no longer a centralized system of regulations applying the broad strokes of Congress to the specific day-to-day life of the agency. There are still the broad strokes. There's still a requirement that every agency consider environmental impacts and prepare an environmental impact statement. It is just not detailed, and it is not clear, and it's not the same standard across agencies. So it's a lot harder to enforce. Because if you're going to argue it in one agency, you can't have the same argument in the different agency with its own guidelines. Hopefully, as each agency establishes its own ideas, its own guidelines, there will become more standardization. But for now, NEPA is a bit weaker, a lot weaker than it was. This order also halted a lot of the funding from the IRA and the IIJ. That being said, those funds were already committed by Congress. And only under a very narrow set of circumstances can the executive delay spending that money. But like I said with the solar example, it has to go out the door one way or another. So what this executive order will likely do on this topic is shift where it goes. But it does still have to be consistent with Congress. Lastly, the order says all relevant agencies should rescind any regulation that's an undue burden on mineral development. Once again, rescinding those regulations requires notice and comment, which means we will all have the opportunity to say why that's a very bad idea, which they have to respond to according to the Administrative Procedure Act, and they have to respond with why it is at least an okay idea. And then there are just a few smaller points. All of the anti-DEI orders largely do not have direct effects on tribes. Going back to a precedent set in, I believe, the 1980s, the term Indian, and therefore all of Title 25 of the United States Code, is a political term and not a racial one, according to the federal government, which means all of these orders do not affect tribes directly. And actually, there was an order from the Secretary of the Interior shortly after one of the DEI executive orders that said as much. It said, none of this will affect our obligations, which are descended from a totally different source of history, the Constitution, and treaties. These are not affected. So at least there is that. The other thing, broadly, if we were to lump all of these orders saying you have to deregulate the 10-to-1 rule, where every regulation must involve taking 10 other regulations off the books, all of those are going through notice and comment process. Every rescission, every revocation of a rule requires a basis, requires an explanation for why. So what can tribes do? Well, now that as of Saturday, I have graduated law school, the lawyer's going to say lawsuits. So tribes, more than any other group or entity, have unique legal protections. There's a constitutional basis, there's a treaty basis, there's the trust responsibility, and there are many specific statutes on the federal government's obligations to tribes. And so this provides a lot of foundation for tribes to say, hey, the law's on the books. You broke it by passing this regulation or enforcing this in XYZ ways. We've already seen lawsuits working to help some of these things. The other thing, just broadly, is the administration has to follow the proper procedures. Without it, that regulation is unconstitutional. Without getting the lawyers involved, there's also the path of government to government talks. Right now, the order saying that the administration must engage or should engage in meaningful consultation is on the books. And so that is a method where, without sort of drawing swords, we can still reach a better result. And then lastly is commenting. All of these revocations and rescissions of rules will be open for public comment. And the administration has to meaningfully respond. Admittedly, there is a lot of space for the administration to say that they considered these well-composed comments and they decided against them. However, the more comments that are opposed to this action, the less likely it is to be found valid, to be found something that's not completely arbitrary. And so that one is sort of a, hopefully, death of 1,000 cuts, just making that voice heard. So to try to wrap this all up with enough time for a good Q&A session, executive action has limits. All of these agencies cannot exceed what Congress has said. Congress is establishing the framework of the House, and the agencies can only choose paint colors, can only fill in the details, can change how the House looks, but they cannot substantially change the House, the laws made by Congress. There's space for discretion when Congress says there is space for discretion. When Congress says we're allocating $1 billion and the agency will know who it goes to, that kind of a thing. Those are the things that can very quickly change. But most every agency action, and for sure every change of regulations, of agency rules, courts can review. Courts can sanction if the rules are not being followed, if the agency is overstepping its bounds. Also, consider that the consultation and coordination policy is still just an executive order. So, emphasize its meaning and appreciate sort of, it would be a lot better if that was statutorily required. And there's an argument that the trust responsibility requires it. However, without that being written down, it's a lot harder to sort of get it to happen. Also, the trust obligation remains. The special constitutional place of tribes in the structure of the US government remains. Treaties, to the extent they do, remain, and specific congressional laws that dictate how the government interacts with tribes remain. And all of those are bases for arguing against agency action. They are bases for finding agency actions arbitrary or unconstitutional. But until election season, it's pretty much negotiation and the courts. And so that is what we have 3 years and change to look forward to. So it looks like we have 12 minutes for a Q&A. I am going to trust someone more tech savvy than me to handle how to run that Q&A. But I'm also going to stop screen sharing so that we can all see each other.
Hey, Rob, as kind of the tech guy here, can you assist in kind of identifying folks who might have their hands up?
Yeah, you bet. At the bottom of your Zoom screen, there should be a react button, and there's a raise hand there. So if you want to ask a question, go ahead and raise your hand, and we'll call on you in turn and have you unmute and ask your question. Or if you want to put it in the chat, we can address them in the chat as well.
I also want to acknowledge that Raymond Paddock, who's the RTOC Region 10 co-chair, is on the line. So thanks, Ray, for making it.
My pleasure. Hi, Rick. Hi, Grant. Great presentation. Thank you very much for that overview.
There is a question in the chat, Grant. I don't know if you see that. I'd be happy to read it if you want to.
I see that. I don't have any knowledge on it. The question is whether any tribe has had one-on-one consultation with this administration. I am not familiar. Most of my research is a little bit removed. That being said, I would assume someone in this chat might know better than me.
Just
So unfortunately,
based off some of the conversations we had with the other RTOCs around the nation, I don't think that has happened. Again, that, you know, not all tribes are participating in RTOC, and, you know, out of, there was, what is there, 575 in the nation. And each of them are their own sovereign nation and can ask for that government to government consultation. Every tribe has that opportunity. But we have not heard from the other RTOCs, at least, any of that kind of happening. So just as in that regards, yeah, I can't say I've heard it yet either. And Rick, I know that you have your ear to the ground quite a bit. Anything you can elaborate on?
I mean, there has been agency level consultation, not necessarily on these big policies. And certainly, I am unaware of any coordination on any level with tribes on these executive orders. I know that's been discussed, that these have come out without any sort of coordination with tribes, particularly the executive orders. It will be interesting to see as there are implementation of some of these, what sort of coordination occurs. You know, certainly the NEPA regulations that are, you know, govern NEPA that were adopted years and years ago by the Council of Environmental Quality, those were revoked by this administration, and I'm unaware of any consultation that occurred with any tribes on that.
Yeah, and that one, they justified the lack of consultation by saying essentially that their hands were forced. That because that council was never able to technically pass those regulations, they were merely doing what they had to. So yeah, that one did seem like a cop out, but
Carl had a couple follow-up comments. It's all been on letters on our end, and have any agencies done one-on-ones, or has it all been group Zooms? And I think, Carl, we don't have a lot of exposure to that. If a tribe reaches out to any agency for one-on-one, that's kind of handled between that agency and that tribe. And the rest of us may not receive any notifications about it. I have seen some letters to tribes, or letters from tribes to agencies, particularly with EPA, that show up in TCOTS on specific issues that do indicate that there's one-on-one consultation going on between EPA and those tribes. I've seen 2 this year. But I think for the most part, we don't have exposure to those.
So I see there was another question on whether executive orders are indefinite, final, or reversible, and whether the only way to reverse them is to go through Supreme Court by suing, or by sort of creating code, which I'm assuming is through Congress. Generally speaking, executive orders last until another administration changes them. They are policies of how to act. And so usually though the smaller ones do change every 4 years. However, a lot of them do have very long terms. So the one specifically on NEPA, that was an executive order that was signed in the late 70s. It dictated how NEPA was applied for the last 50 years. I remember there was also one that was signed by Lyndon Baines Johnson on contracting and diversity. That one governed how the government handled that up until it was revoked by Trump. So most of them last until they are taken back. As far as the only way to change them, it would be very difficult to change the executive order through the Supreme Court. And that's largely because the order itself is not meant to change anything. The order itself is not meant to act directly on people. And so it's very difficult to sue, go up to the Supreme Court or any court and say, this will result in these other changes, just because of kind of a history of the courts not wanting to answer questions. But honestly, I would say the much better plan of attack would be going through Congress to change the basis, sort of changing the rules that the agency has to abide by, or by going through the agency when it tries to implement or apply the executive order.
And Grant, just to point out, executive order, I think is 13175, which is consultation, is still in place, as I think you pointed out during your presentation, and was adopted by President Clinton. So these can last unless they're revoked.
There's another question in there. Alaska has a number of co-management bodies that are recognized and utilized in management of marine resources. Have you heard or worked with any of these governing bodies?
I don't work with virtually any bodies of interest beyond the RTOC. However, I trust that other people could address that.
On our part at Clinton and Haida, we have a co-stewardship aspect with the Forest Service at the Minhall Glacier, but I haven't heard anything in Southeast, at least in regards to anything on the marine aspect of things in co-management or co-stewardship.
Thanks, Ray.
Yeah, one quick note though is I believe it was right at the end of Biden's term, he did pass an executive order that tried to sort of heighten the significance and like essentially have the federal government recognize more consortia and just larger bodies for tribal interests. And that was only in effect for 2024. It was passed December 2023, in place for that year, and then immediately revoked. So that one is sort of, if there was sort of an on the ground change over that year, that might go back, but largely back to the status quo before that. So we also have a question about executive orders that are contrary to or violate Supreme Court precedent. And that one, so the one that comes to mind is the birthright citizenship one. And that because they didn't actually have the basis to enforce it, very quickly did go to the to a lower federal court. And I'm not actually sure of the steps between that order and the implementation, but it's sort of, once that passes through, would that be ICE or Homeland Security that then had to change its policies? And it's that's the thing being argued. It's sort of the last final step that creates the on the ground effect. So the executive order can just be told to be or held to be irrelevant, but it's not actually going to be revoked by the Supreme Court. The Supreme Court's just going to say, good luck with that. You can't do that, though. Other question is, where is NCAI in all this? And I do not know that answer either.
I know they're concerned. I don't know specifics of what they're doing. I know they've had some webinars and discussions about executive orders and as they, how they impact tribes. But as far as what they may be doing in DC, I'm not aware.
We're about a minute past our time. Thanks for everyone who joined. If you need to leave and get on with the rest of your day, do so. I think we can stick around for a few minutes and answer any additional questions.
Thank you all for attending. I appreciate the interest.
Great job, Grant.
Yeah,
And
thank
thanks
you
to all
all
of you
for
who
attending.
attended.
And if you have other topics or ideas of things you'd like the RTOC to focus on, please let us know. And Rob, there's been a number of questions about whether or not this will be available. Is this something we could post on our website, or is this something people have to email?
We have it in the recording. It'll take me a little while to turn the recording around. And if all parties are interested, we can put it on our YouTube channel and link it from our website. We can embed it on our website. We've got some options there. I saw one person asked if the PowerPoint would be available as well. We can certainly do that as well. We can turn it into a PDF so it's easy to download.
Great. Thanks, Rob.
Yeah, thank you, Rob.
Really quickly, I did want to address, there was a comment in the middle of that of the options to enforce compliance with a court order. And that's another one that goes to the theory versus the practice. In theory, the court is able to issue contempt orders to make sure that that original order is followed. There were a few examples in between. Well, actually, there was one particular example during Trump's first term in which the Department of Education was told that they couldn't collect student loan payments. They did so anyway, and then the court assessed, I think, $100,000 contempt order, which ostensibly would just keep going and piling up the more that the executive did not follow. That was one where it worked. The administration eventually fell in line, followed suit. In between Trump's two terms, there was a civil case against Trump where the court also issued a contempt order, said, hand us the documents, we will fine you $10,000 every day you don't. And that took 2 weeks before an arrangement was found. So, in a sense, it worked. It's unclear, though, what would happen if he was really adamantly opposed and wanted to test it. Testing the system, you still have the contempt orders, and you have the federal marshals, which are tasked with enforcing the court's orders. The federal marshals are organized under the Department of Justice, which is an executive branch. If a lot of sort of the norms, a lot of the sort of black letter written law works, that's how that gets enforced, through the federal marshals, through contempt orders. If that's not how it works, then I am definitely out of luck just as much as everyone else is in knowing what happens. All right. I'll just quickly answer one last question that popped up here, and then I kind of have to run. The question is whether they're looking at assigning a value on natural resources. Broadly, not that I've seen. If they are, that would be a much narrower thing that would be an agency action specifically. But I have not seen any sort of broad executive order saying this is how we're valuing it. It's pretty consistently going to be a balancing of different values.
All right, Grant. Well, thank you for your time. Thanks everybody for participating. And as we said, we'll make this available. Oksenia, do you want to close with anything or?
Yeah, I just want to thank everybody for joining us today. Grant, great job. And I wanted to remind everybody that we do have a couple of town halls coming up in a couple of weeks. So there will be a town hall for Alaska Tribes on May 27th and then a town hall for tribes in Washington, Oregon, and Idaho on June 2nd. And we will send out some more information on those with agendas and how to sign on to that in the coming days. So thank you all for joining.